One third reading, we'll go right to third, and then we'll go back up. What's that? Right, got it. Okay. Bills on third reading. So we are on House Bill 181, third reading. Reading clerk will read the bill.
House Bill 181 engrossed online sports wagering amendments sponsored by the Appropriations Committee, an act related to gaming.
There is an amendment. We have the amendment ready.
House Bill 181, third reading amendment number 1 to engrossed copy, page 10, line 11, delete.
Senator Cole.
Move the amendment. I move third reading amendment number 1 to House Bill 181 and ask for your favorable consideration. This amendment's pretty, it looks pretty short and compact, but actually it has broad impacts. It basically takes the number of months that can be written off for a loss in the preceding month to 2 months. They can take it over 2 months. This amendment shortens it to 1 month. And frankly, what I first didn't realize about this amendment is the current structure of the 2 months that you can take the loss will overlap, because the next month you can get the next month. So basically in every 1 month, and in any 1 month, you could have 2 write-offs to make sure that that you didn't show a profit. So what this does is this is a benefit to the state of Wyoming. In the bill that we have in front of you, on its face, is much improved. This goes one step further and just shortens the time period from 2 months to 1 month. And I'll stand for any questions, and I'll speak for my second time when it's time to do so. Thank you, Mr. President.
Thank you, Mr. President. Mr. President, when we talked about this on Committee of the Whole, I believe, the one reason I thought it made sense to have 2 months instead of 1 month was simply from the logistics of reporting and making sure that you had finalization of all of the information that would be coming in on what is presumably a monthly series of receipts. And then based on that, you would then have sufficient information to pay as required and file the information. So my question is really from a logistical standpoint, does it make sense to go to 1 month? I have no objection certainly to going to 1 month, Mr. President, but I guess I'm curious whether it's workable to go to 1 month, and hopefully somebody that is more familiar with this process could potentially stand up and help the bringer of the amendment prior to their second time, because I think it's worth discussing just the logistics of working through it as opposed to the reasonableness of the intent, which I support.
Thank you, Mr. President. Those of us on the working group on this bill went through before, as I mentioned when I was explaining the bill, it just went, there was no cap on it. It just went on. And so working with the industry, we settled on 2 months. And yes, if there were recurring losses, it would go over. As time goes by, this will be less and less of an issue as their dollars build. But yes, on occasion for that big event, if there were significant losses, we felt it was fair to split the difference between on infinitum to down to 2 months, and that's where we settled. When I talked about the bill, I said we talked about 3 months, we talked about 1 month, we did, and I suppose it's by saying that I left that open to be 1 month. The only thing I'd say to you is vote it up, vote it down, the amendment. I'm going to vote no only because I was part of the group that agreed to it. And so and we thought it was fair. We thought it was fair for the industry and fair for the state of Wyoming, who's in this as partners with this as we are with a lot of industries that we work with. So that's basically it. As far as your question about carryover, we didn't delve that far into it. We just worked upon, as far as the bookkeeping end of it. I know it was discussed about the bookkeeping facet of it, but I don't recall that being the main sticking issue of it. It was just saying what was fair. That the 2 months was more fair than going on just on infinitum. So on and against the amendment.
On and for the amendment, Mr. President. In discussions, there was another member of the Appropriations Committee and I who wanted to bring this amendment in the committee, but working through the bill, we just didn't have the time to get it prepared. And so I'm glad to see this amendment here in strong support of it, and hope you will be too.
Thank you, Mr. President. So I think the question from the minority floor leader was, the practicality, the implementation. I think if you look on page 9, line 9 of the bill, there's already a reporting requirement and actually a remittance requirement by the 15th of the month following. So it seems like it is a very timely process. So having, whether it's 1 month or 2 months, I think it fits well within what the current operation is, or the current understanding is. So thank you, Mr. Chairman.
Mr. President, I rise, I hope that the sponsor in his second time, somebody can give a little better explanation of what's really going on here, because, Mr. President, I'll convince I've been trying to listen to the debate, and frankly do not understand the basics of what we're trying to vote on here.
Mr. President, thank you. And just to add to those questions, is this an effort to save money, and how does it work? That's what I need to hear. I don't have any problem going to 1 month and would try to support the amendment, but I just don't know if it works. And I'm not sure exactly the purpose of the amendment. That would really help me. Thank you.
Thank you, Mr. President. All good questions. So I'll lay out a scenario of why this is really an issue and has been an issue. There's been online sports credits given, okay? And I'm looking at one right in front of me now. It says, hey, Wyoming, get a deposit bonus up to $1,000. Where all do you think that credit's coming from? They use that credit, the giveaway, against what they owe the state of Wyoming, because it's a loss. They'll claim a loss, and then the next preceding month or months in the past, they would just take that loss forward. And conveniently, our revenue is cut down. So this is an attempt to square this up and say, folks, I do understand as a businessman that sometimes you're gonna run into issues, and maybe you do have to, get a loss credit, is what this is about. But instead of letting it go on forever, compromise originally was 2 months, and this takes it down to 1 month. I pose the fact that these folks have calculated out exactly their losses and how much they can lose every month to go against the credit to basically make it a very low income or zero revenue for the state of Wyoming. So this is an effort to kind of square things up and be fair. And I think if anyone searches online, you can see all these bonuses and giveaways too. This is the largest one I've seen, is $1,000, but I'm not an online bettor. But this amendment's going to benefit Wyoming. It's going to benefit our revenue situation by restricting the ability for the online gambling businesses to continually post losses. Because why wouldn't you? Why wouldn't you? If you're giving away $1,000 to people, obviously you can take that against your bottom line and post a loss, or at least zero revenue to the state of Wyoming right at the end of the day. So I guess in closing, I'll say It's a fair bet that the odds are in the online sports wagering entity's favor. Let's even it up so Wyoming gets more of its fair share. I call for the question.
Thanks. I'd ask that the amendment be divided. Lines 1 through 4 are Division 1. Lines 5 and 6 are Division 2. That would allow everyone to speak 2 more times in each division. I'd encourage, Mr. President, for you to vote the same regardless of.
Point of order, I believe that was the sponsor's second time on that amendment.
Mr. Yeah, Mr. President, which is exactly why I'm doing what I'm doing. Yeah. So Division 1 would be lines 1 through 4. Division 2 would be lines 5 and 6. However you vote, vote the same on both of them. And Mr. Chairman, so on Division 1, that's not, the explanation that was just given was not really what I understood as the original intent, and I think it's worth having a little further debate. And I guess the question I have is I think through the math of that, regardless of whether you vote for this or not, it does not seem to solve the problem. Because again, I can generate a loss based on the credit for any given month, just as well as I could do that over a span of 2 months or 3 months or 5 months or 6 months. I just have to make sure that my ratio of loss to income is the same under all circumstances. In other words, I generate a certain amount of revenue each month. I can generate up to that amount of revenue each month. It doesn't matter whether I include that over a 6-month cycle, a 3-month cycle, a 2 or a 1-month cycle. It's the same potential loss that I can work against and build the state. So I guess I'm failing now to understand if that's the motivation, is to try and shore that up. Mathematically, Mr. President, I don't think it does that. And I would just note before I sit back down that, again, the good sponsor of the amendment still owns both divisions and is entitled to 2 times on each of the divisions, as well as on each of the divisions the last word, Mr. President. Thank you.
We didn't need to hear that advice, but Senator Drew.
Thank you. And actually, with the good bringer of the amendment, we couldn't have, on the working group, couldn't have agreed more, which is exactly why on page 2, line 9, or actually line 11, where we say online sports wagering revenue means the total of all wages placed with patrons on online sporting wagering operator, excluding the actual dollar value of free wagers and promotional play provided, minus all payments. The value of the ad of which the bringer spoke has a cash value that is far different and far less than what the actual value that they say it has. And you see that all the time on advertising, and you see that. And so we saw that and went to the operators, because it wasn't that way before. They got the actual value of the promotion. That's why we changed it to actual cash value to take care of that. What the 1 month, 2 month, and as the last speaker said, that won't change with 1 month. That will just go 1 month to 1 month. And it's really not that much money when you could change it to actual cash value. Now, what the 1 month carryover to 2 months was about large events. We had one yesterday in this country, a large sporting event where lots of money is wagered. What they tried to do, of course, with betting is attract equal wagers on both sides. That way that they win and we all, some win, some lose. But every once in a while, they get off and they get one that they miss and something happens and they lose millions and millions of dollars. What all they're saying is on that very rare occasion, they would get to carry over some of their loss. Do the gamblers get to do that? No. So I'm just total transparency there. When you lose, you lose. But this is something that, they too invest a lot. This is what I say. They invest a lot of money too to set this whole system up with geofencing and all the other things that they do to make sure that the wagering stays legal, stays inside the state, that a lot of expense is generated there. So that's what this is about. And that was what the 1 versus 2 months was about. but it really is not going to capture what the essence of what I heard the bringer was trying to provide. And I thought we already provided a remedy for that. Thank you, Mr. President.
Further discussion? Further discussion? Question being called. So these are going to have to be roll call votes because they do involve money, I believe, the way they're done. So are you able to do that? Okay. So we're on Division 1 of House Amendment Number 1 to House Bill 181, third reading. Senator Rothfuss?
I don't think they involve money. I think a voice vote would be.
I'll go with that way. We'll do a voice vote then. I'm happy to do that. I came close now. Well, all right. So we're on Division 1 of third read amendment number 1 to House Bill 181. Division 1 is lines 1 through 4. All in favor, say aye. Aye. Opposed, no. Ayes have it. Division 1 is passed. We're on Division 2, discussion. Yes. I'm thinking about it.
Thank you, Mr. President. With Division 1 passing, it would be a good decision to also pass Division 2.
Thank you. Question being called. Senator Cole.
Well, I'll speak to it. Obviously, from the explanation, this does no harm to change it from 2 months to 1 month. Thank you, Mr. President.
Question being called. We're voting on Division 2, third reading amendment number 1 to House Bill 181. All in favor, say aye. Aye. Those opposed, no. Division 2 to third reading amendment number 1 to House Bill 181 is passed. Third reading amendment number 1 to House Bill 181 has passed the Senate. We're back on the bill. House Bill 181 have been read House Bill 181 haven't been read 3 separate times. The question is, shall the bill pass? The Chief Clerk will call the roll. Now we're on roll call on 181.
Third reading roll call for House Bill 181. Anderson. Baldwin. Barlow. Beitman. Boner. Bouchard. Brennan. Case. Cooper. Dockstetter. Ellis. French. Murphy. Peru. Hicks. Hutchins. Ide. Jones. Kinski. Kolb. Landon. Larson. McCune. Nethercutt. Pappas. Rothfuss. Salazar. Schuler. Scott. Steinmetz. President Driscoll.
Aye. 3 votes.
I just need to verify Senator French. I just need
French?
to re-verify the vote. Senator French? Aye. Cooper, no to aye. Hicks, no to aye. Senator Furphy, could we verify your vote again? No to aye. And Senator Garuk, aye.
Was that a no to an aye?
Okay. Closing vote. Oh, Senator Dexter? No to aye. Closing vote. Closing vote. Vote closed. By your votes, House Bill 181, 25 aye, 6 no.
House Bill 181, having received the affirmative vote of the majority of members elect to Senate, House Bill 181 has passed the Senate. Includes third reading. Got one conference committee I appointed right before lunch that we're going to change a member on. This is Conference Committee on House Bill 41, Message 284. We will swap Senator French with Senator Brennan on the conference committee. Chair will stay the same as Hicks, so it will be Hicks chair, Brennan, and Jones. Senator Jones, thank you. Signing of enrolled acts. That order of business, signing enrolled acts. Enrolled act number 5.
Senate Enrolled Act Number 5, being Original Senate File 13, an act relating to alcoholic beverages, amending bar and grill liquor license requirements, specifying sunset dates for bar and grill license population formulas, providing for rulemaking, and providing for effective dates.
I'm about to sign Senate Enrolled Act number 5, the same being original bill number 13. I have so signed. Messages from the House.
From the House of Representatives, February 13, 2023. Mr. President, the following bills passed the House on third reading by the votes indicated. Senate File 5, Medical Malpractice Statutory Update. Message number 308, Senate File 14, Wyoming National Guard Professional Malpractice Liability, ayes 62. Message number 309, Senate File 15, Military Leave for State Employees, ayes 62. Message number 312, Senate File 33, Defining Aircraft for Purposes of Hunting Prohibition, ayes 61, noes 1. Message number 313, Senate File 36, Investment Funds Committee Selection Panel Amendments, ayes 62. Message number 314, Senate File 55, State-Held Drainage District Bonds, ayes 61, noes 1. Message number 316, Senate File 118, Fund Balance Calculations, Federal Encumbrances Excluded, ayes 62. Message number 317, Senate File 122, Non-Resident Workers Vehicle Registration Extension, ayes 62. Message number 318, Senate File 26, Psychology Interjurisdictional Compact, ayes 36, noes 26. Message number 310, Senate File 17, Off-Road Recreational Vehicles, Safety and Insurance, ayes 45, noes 17. Message number 315, Senate File number 28, Livestock Infectious Disease Control, Tribal Inclusion, ayes 56, noes 6. February 13, 2023, message number 307. Mr. President, Senate File 6, Insurance Rebating Modernization, passed on third reading in an amended form, ayes 61, noes 1. The House respectfully asks the Senate to concur by adopting amendments. Message number 319. Mr. President, Senate File 42, Taxation of Cigars, passed on third reading in an amended form by the vote indicated. Ayes 46, noes 16. The House respectfully asks the Senate to concur by adopting the amendments. Signed, Katie Talbot, House Chief Clerk.
Randy, do we have any standing committee reports? Apparently not. Okay, very good. So at this point, we're going to go to the Manual of Legislative Procedures. Senator Rothfuss, you prepared to present? Senator Dockstader, I'm going to leave the desk if you would come man the desk for me through general file. Thank you, Senator Rothfuss.
Thank you, Mr. President.
It's mandatory that you all stay on the floor.
Absolutely. Mr. President, I move for the adoption of draft 0.209 2023 Wyoming Manual of Legislative Procedures. And Mr. Chairman, I'm going to hit a couple of highlights, talk about the process, talk about what this is. This is about, I think we're at 70-ish pages, maybe somewhere in that ballpark. I have it on good authority that in the other side of the building, they walked through it, and that was about a 45-minute endeavor just to get through it. So we're not doing it that way unless somebody has very specific questions. We'll hit some of the key highlights. But Mr. Chairman, the process and the intent of this is we have this Wyoming Manual of Legislative Procedures that backstops our rules and regulations. It's already in place, but it hasn't been revised in a number of years. During the interim, the Management Council took it on as a little extra workload, assigned a working group from the Management Council to take a look at the Wyoming Manual of Legislative Procedures and to offer suggestions of updates. The work on the manual was actually done by one of our longstanding LSO dinosaurs that has been around this institution for quite a long time and was certainly the right choice in trying to codify standard procedure and precedent and tradition into the Wyoming Manual of Legislative Procedures for our consideration. And the work then was done by that individual, brought to the task force to understand it, and then recommended to the Management Council, which then brought it to our Rules Committee and Joint Rules Committee for consideration during this legislative session. So, Mr. Chairman, this is effectively a part of the rules, but at a lower level than the rules. There are 4 key changes that I want to talk about, but I want everyone to understand what this is. It's effectively a written form of standard practices of how things are done in the Wyoming legislature. So it goes into all of the different readings, all of the different standard practices. And instead of the short form like we have in the rules, it kind of goes into a long form of this is how we do things in the legislature, this is how we do things in the House, this is how we do things in the Senate, Mr. Chairman, and tries to lay out that procedure so that everybody can better understand it and have information. So, Mr. Chairman, I would say then that it is effectively a codification of our standard practice and our tradition, and is intended to be treated as such, which gets to the first key provision that I want to go over. If you go to the true page 1, which is after the table of contents, this was a point of policy discussion where you see a part 1, which talks about the Wyoming Manual of Legislative Procedures, what it is and how it works. And you see that the authority of the Wyoming Manual of Legislative Procedures is specified in Joint Rule 10 and Senate Rule 11, House Rule 11 addresses the nomenclature for Wyoming Manual of Legislative Procedures. The precedence of this manual is also addressed in this introduction. So this is a key provision that actually was debated, discussed, and is a significant part of the policy, and that is what is the standing of something that is in the Wyoming Manual of Legislative Procedure. And the key provision that I'd call everyone's attention to for the standing is what you see in item 1. The provisions of the Wyoming Manual of Legislative Procedures may be suspended as to a particular action of a House by a majority vote of the elected members of the House or elected members of the Senate for actions in their respective bodies. Mr. Chairman, what that means is the Manual of Legislative Procedures is the order of business that we will follow right up until the chamber decides it doesn't want to follow it. So if a majority of the body doesn't want to follow the Wyoming Manual of Procedures, a simple vote saying we're not following it this time is sufficient. So a majority of those can override it, and that's by intention. Because these are below rules. Rules take a 2/3 suspension, I would remind the body. So if it's in the rules, it has a high threshold before we would suspend that. If it's in the Wyoming Manual of Legislative Procedures but not otherwise specified in rule, a simple majority is going to override that. And similarly, in the 2-paragraph, a ruling of a presiding officer based upon an interpretation of the Wyoming Manual of Legislative Procedures can be appealed to the body by a simple majority, Mr. Chairman. So the idea there then is if a ruling is put to the chairman based on the Wyoming Manual of Legislative Procedures, and the body disagrees with a correct ruling of the chair, a simple majority overrides that, because again, it is not tantamount to rules, it is our procedures, our traditions. And so the working group that put this together wanted to make it clear that it did not have the full force of rules, but was effectively our tradition, our standard practice, but it was subject to a majority of the chamber to override, not a 2/3 majority. So, Mr. Chairman, that is the first provision that I wanted to take a look at. The second you see at the bottom of page 1.
Mr.
Go ahead.
Rothos, should we see if there are any questions?
Yeah, that's a good
on the
idea.
first one?
Let's walk through it that way.
Now,
So
in the first
it's an
section-
important consideration. Let's work on that one.
Any questions for him at this point? Any questions? Carry on, Senator Rothos.
Thank you, Mr. Chairman. The bottom of that page is the codification of the limit of 15 co-sponsor requests by extranet. That's actually standard practice, but this codification is something that we put in the Manual of Procedures. There was a lot of discussion around it, but I just wanted to call to everyone's attention that at the end of the day, it still ended up at 15. The House spent a lot of time working on it. There wasn't a lot of consternation on the Management Council, and it stayed at 15, but I wanted to draw that to everyone's attention. Mr. Chairman, as we move through, I want to point out the fact that those things that I'm not explicitly addressing are simply a reasonable way to write down the way we already do things, and that's why I'm not raising them. They shouldn't be contentious because it's just the way things are done now. And if anybody has any questions about any of the provisions, any of us that we're working on it are happy to address it.
Questions on the provisions? Senator Scott, go ahead.
Chairman, are we under the speaking twice on any subject rule, or is this open debate as it would be in committee of the whole?
Senator Rothos?
Yeah, Mr. Chairman, we'd technically be on the any two, but we can suspend that rule by 2/3 because I think it probably deserves a lot more than 2 votes. So I would move to suspend the 2-speech rule for the purpose of consideration of the Wyoming Manual of Legislative Procedures and call for the question on that. We need a 2/3 majority, or without objection, I guess I would just
Without objection.
ask
Let's
that
do that.
it be suspended.
Absent objection, we'll suspend those rules for 2. All
Now we
right.
can talk as many times as we
ahead.
want, Mr. Chairman.
Now you've seen it. Go ahead, Senator Scott.
Mr. Chairman, and I will say, I had no idea this was coming up and saw it about 2 minutes before we got into it, and have great reservations as to what we're doing here. Mr. Chairman, why the limitation on the number of sponsors? I know that has been the practice. I've seen it violated. Why is that in here, and what are the practical effects? Because my perception is that this system doesn't work.
Senator Rothos?
Thank you, Mr. Chairman. Mr. Chairman, nothing has changed from the existing policy. You can have as many co-sponsors as you want. You just can't do it through the simple extranet. The extranet has a limitation built into the software of 15. If you want more sponsors than that, you're going to have to do a traditional paper copy approach to it, which is still in order. Nothing has changed with regard to that pathway. So again, there is a standard path, as we've done in the past, to provide, I think we effectively have unlimited on bills at this point, as long as you do it through a signature process instead of the extranet. And Mr. Chairman, this is how it's coded in the software. It's not to say we couldn't open it up, but the intent in the discussion was to try to provide some semblance of a limitation for the processing and handling and management of it. Again, I'll just reiterate, Mr. Chairman, a lot of this is not a policy that I'm either advocating for or against. Mr. Chairman, it's the policy we have now written down. So there's only a few cases where this manual of legislative procedure is doing something different. And Mr. Chairman, the working group that came together to do this, our intent was to not change anything. That was our task. Codify what we do now as the Manual of Legislative Procedures, which is subject to amendment and revision over time, but that wasn't our task. Our task was, how do we do it now? Make sure this reflects how we do it now, unless there's some vacancy that we have to fill in. And I'm going to try and point out 3 other places where I feel like we kind of made decisions as opposed to just doing it as now. So with regard to this 15, Mr. Chairman, I'm not going to advocate for it. I'm not going to advocate against it. I'm just going to say it is a literal translation to the best of our ability of the policy that is in place right now.
Any further questions on this? Proceed.
Thank you, Mr. Chairman. So again, I'm going to skip pretty far ahead at this point, just highlighting key changes. And the next point that I wanted to say was clarified in a way that might not be existing standard practice is all the way ahead to M.3, page M3, moving quite a ways through the draft. So I'll wait a second for those that want to catch up to M3.
M3, go ahead. Go ahead,
All right,
Senator.
Mr. Chairman. So M3 at the bottom, the 2 paragraph, talks about proxy and absentee voting in joint interim committees. So we have called absentee voting proxy voting, and that's why I want to raise this. Proxy voting is when you hand someone else your vote and they vote for you. That is against the Wyoming Constitution. That's not allowed, and we've never really done that. But we've called absentee voting proxy voting. So we clarify that here, that you see at the beginning, proxy voting shall not be permitted in joint interim committees. That's officially a new policy, even though it's effectively unconstitutional. So it's just codified in the Wyoming Manual of Legislative Procedures that nobody gets to borrow someone else's vote and then cast it on their behalf. That is an unlawful delegation of legislative authority. The rest of the paragraph is what's called absentee voting, Mr. Chairman, which is the practice that we frequently use at joint interim committees, where you're there for a portion of the meeting, you're leaving, you're heading home a little bit early, maybe you've got to teach a class, for example, and you leave a vote behind, but you've been a participant. And so this clarifies, you can see, a policy that has been vague in the past. And it's gone different ways, and that's why I'm calling attention to this, because this is an actual clarification of what we sort of took as the policy, but realistically it's been done enough different ways that it was hard for us to really be confident that it was a true codification. So I want to call everyone's attention to this language. Absentee voting in joint interim committees is subject to the discretion of the chairman. In exercising discretion, the chairman shall announce the standard at the first regularly scheduled meeting of the committee and apply the same standard throughout the biennium. If the chairman fail to announce the standards at the first regularly scheduled committee meeting of the biennium, absentee voting shall be permitted. So it's permitted by default unless a policy says otherwise. And then here's a key provision based on how we believe it is practiced, or how the group believed it's practiced. Absentee voting in joint interim committees shall only be allowed for members who have attended a substantial portion of the committee's discussion of the issue. In other words, Mr. Chairman, you can't just miss the interim committee meeting and then hand over, I vote aye on this one, I vote no on this one, I vote aye on this one. You have to attend the interim meeting, you have to be a part of the debate to have that benefit available to you, subject to the chairman's policy. And we believe that was capturing how it's been practiced, but we can't say for certain that's the only way it's been practiced. So I wanted to point that one out and see if there's any questions, because we think that's the most appropriate capture of how it's been done.
Questions on this part? Any questions? Please go ahead. Oh, Senator Scott?
Mr. Chairman, absentee voting joint interim committees should only be allowed for members who attended a substantial portion of the committee's discussion on the issue. Couple of points there. It's not clear whether it's the discussion at the meeting or it includes previous meetings where there've been some discussions of the subject, and it's not clear how you weigh those, because frankly, the memories are fallible at that point. And I must say, I think I've seen absentee voting from members who maybe had known positions and did vote absentee, but really hadn't attended much of the discussion. Mr. Chairman, I think there's a vagueness in this area.
Senator?
Thank you, Mr. Chairman. Mr. Chairman, to the good tall senator's point, there is an intentional vagueness to it. It is written based on an understanding of the good senator's thoughts and his various interpretations of it. And it falls back to the second sentence of the paragraph. Absentee voting in joint interim committees is subject to the discretion of the chairman. And when we talked it through, we felt once again like this was our best encapsulation of how it's pretty much being done. And there probably has been different interpretations among different chairpersons as to how to roll it out. So, Mr. Chairman, I won't say this is the best policy, I won't say this is the worst policy, but this was our best job of capturing how we think it's done.
Senator Pappas?
Thank you, Mr. Chairman. Just a question, since this is Appendix M for interim committees, and I haven't had a chance to look at yet elsewhere in this document, I'm assuming for standing committees in session, it's probably in part 2, I would imagine. Are we doing anything materially different between the two?
Senator Rothfuss?
Yeah, Mr. Chairman, recall for our standing committees during session, we effectively have a full process that allows for absentee voting, where you leave a ballot and there is no requirement that you participate in any way in the debate. So it is very different based on our standard practice. And we all know that during the interim committee, you might not be able to attend even a moment, as it turns out, of one of the standing committee meetings, and you frequently do leave your vote for that. You leave your best vote, best you've got, and you hope to attend if you can. And that's again what we encapsulated for those, which is a clear encapsulation, I think, because that's I think that's a universal process, and I haven't seen much deviation from that. So I didn't raise that one to walk through. Appreciate the
Questions,
question.
Senator Landon, did I see you stand?
Mr. Chairman, thank you. I just wanted to come back to the point at the bottom of M3 and that final sentence, absentee voting in joint interim committees shall only be allowed for members who have attended a substantial portion. That was actually, we spent quite a bit of time on this paragraph, and that was actually something that we added in the language to give a little bit of cover for our chairman. That chairman discretion is paramount. But this also sets a level of expectation the membership, I think, during those interim committees that, you're expected to know what you're voting on. And, but ultimately, discretion of the chairman. Hope that helps too.
Hey, Senator Rothus.
Yep. Anything further on that? Seeing none.
Let's go ahead.
Next is O1, page 1, a couple ahead.
Go ahead.
This is something that is codified. I don't know that it was codified before, and it's something that is a policy that LSO uses that might not be intuitive, but it is the standard practice right now. So I wanted to call it to everyone's attention, and this relates to confidentiality of amendments, which is the 3-point. We're all used to, for bill draft requests, confidentiality is the starting point, and until you waive confidentiality, that confidentiality will be assumed. So the basis on a bill draft is full confidentiality until you waive. I'm not sure if everyone is aware, and this is the codification of it, but this is the practice that is under use, that for amendments, it's a little different. So you see, the general rule is an implied waiver of confidentiality. So an implied waiver of confidentiality under circumstances where another legislator has a similar amendment request, and that waiver is only with regard to that other legislator. So what that means is if you ask that an amendment be drafted, and another legislator asks that a similar amendment be drafted, your LSO attorneys will default to pointing it out to each of you that there are similar amendments, who that other legislator is, and say, hey, you might want to work with the other good senator on a common amendment. That's different from other practices. Once again, though, Mr. Chairman, you can say, I don't want that to happen. You can request full confidentiality, and then that implied waiver will vanish. But it's just important to realize the starting position on an amendment is different from the starting position on a bill, and I'm not sure everyone fully appreciates that, so I wanted to raise that one. This is a new codification that I don't think I've seen written down before. So,
Thank you. Questions for Senator Rothus? Keep going, sir.
thank you. And the final point that I wanted to raise, and then I'm happy to address anything else, is on the very back page, Q1.
Q1. Go ahead, Senator.
So we have not codified this, but this is how it has been done. And there was a request specifically to codify it because it's useful to have it on paper in the Wyoming Manual of Legislative Procedure. This would technically not really be something that's waivable pursuant to the Manual of Procedures, but we wanted to get it written down so that everybody understands the procedural hierarchy. So the top of the hierarchy of what binds us are constitutional provisions and judicial decisions thereon. Those are the highest binding. Next are our adopted rules. So if it's in the rule, you're going to go to it after the Constitution. Then comes this document. This is in third place. The Wyoming Manual of Legislative Procedures falls into third. Custom, usage, and precedent, which is largely codified here, but might not be, would be next. Statutory provisions related to legislative procedures would be the next point. So if we have something in statute, it falls below our rules and falls below our custom, usage, and precedents. And I think we talked about that previously, Mr. Chairman, that that's because we bind ourselves as the Senate. We do not adhere to the decisions of the other body, and as such, statute falls below our rules. Then adopted parliamentary law, which is our Masons. I probably shouldn't have said that. No, it's okay that I say that, I think. And then finally, other parliamentary law. So that's the order of the procedural hierarchy on paper. Sometimes that comes up in question, and here we have it now in the Manual of Legislative Procedure codified clearly where it hadn't really been fully clear before. So, Mr. Chairman, those are the points that I wanted to raise, and I do understand that many of you might not have delved into this deeply. And Mr. Chairman, we could decide it, I'd look to the good majority floor leader to decide how we want to proceed, whether we want to provide some opportunity to chew on this and vote on it later. We've got a motion on the floor that I made. I'm happy to withdraw that if you want more time. I'd look to others to decide how we want to proceed.
I think we've come to the conclusion. I'll let the floor leader say it, though. Go ahead.
Mr. Chairman, my preference would be to withdraw the motion, allow the body to look at this tomorrow and review these. We've had an explanation, come back, bring this motion back, and then if there's additional discussion, we need to have at that time and then vote on it tomorrow, Mr. Chairman. That would be my preference.
So an absent objection, the motion withdrawn then? Okay, the motion's withdrawn. Everybody understands what we're doing. Coming back tomorrow. Gives you a chance to think about it. Senator Landon.
Mr. Chairman, thank you. Just real quickly, I really appreciate how the minority floor leader went through the document. I thought he touched on the most important things, but lots of information in here. And if you have any interest in how this all came about, we can certainly visit more with you. You, Mr. Chairman, appointed me to be one of the representatives for you on this. Was glad to serve, but this took place last summer. We spent quite a bit of time on it.
We added
We
to your
had some
summer
of our best
workload.
legal minds who happen to be associated with our legislative branch. And anyway, just wanted to throw that out, that we'd be very happy to visit at any time about processes or what we tried to put in. So
Summer of work. Thank you for
thank
your
you.
work. Okay. Senator Scott.
Mr. Chairman, will you entertain another question on this subject, or you want to hold that?
Sure. We can bring Senator Roths back. Go ahead. Go ahead.
Mr. Chairman, on the sample rules for interim committees, what do they provide as a majority for the committee to sponsor a bill? Is it a majority of the members in the committee or a majority of each house's members?
Go ahead, Senator.
Mr. Chairman, so we moved those out of the Manual of Legislative Procedure, and those are codified in the joint rules. And Mr. Chairman, I believe that's the area where we have a difference in our joint rules, if I'm not mistaken. At least that's a portion of it. I don't remember if we codified that or not. But I think the baseline, Mr. Chairman, is that it's a majority of those, of all members, all regardless of chamber, as the baseline, and you would have to make a motion to amend it if you wanted a majority of each chamber voting separately. That was a point of consternation between the two chambers, but I think in the joint rules, which again is not the legislative procedure manual, I think in the joint rules it has that. I'll look it up, Mr. Chairman, and verify.
We do have just some open discussion now, if anybody else would like to ask. Okay. Doesn't appear to be. Thank you, Senator Rothfuss. Thank you for your work. Thank you, Senator Landon, for your work. Very good. Mr. Floor Leader, what would be your desire?
Mr. Chairman, I move that the committee, excuse me, Mr. Chairman, I move the Senate resolve itself into committee of the whole.
Thank you. You've heard the motion. All those in favor say aye. Those opposed, nay. Senator Cooper, you're in the desk, and I've drank all your water, so you need a new glass. Thank you.
Okay. Committee of the whole will come to order. Senator Hicks, or Mr. Majority Floor Leader, excuse me. Mike, I knew that.
Mike's over there. Mr. Chairman, so we've got 4 bills. We're gonna work on general file today, and then that's it. So we're still waiting for you committees to get some stuff cranked out. So, Mr. Chairman, you're the only thing between them and getting to their committee meetings this afternoon.
All right. So the first bill for our consideration today is House Bill 175. Will the reading clerk read in the bill, please?
House Bill 175 engrossed excused absent state fair events sponsored by Representative Strzok, an act relating to student attendance. Was referred to committee number 4, which returned to committee recommendation that it do pass. Ayes, Senators Beitman, Brennan, Rothfuss, Scott, and Steinmetz. Senator Scott, chairman.
You've heard the reading of the bill. Senator Scott, what's your pleasure?
Mr. Chairman, I move when the Committee of the Whole rise and report it do so with the recommendation that House Bill 175 do pass, and I yield to Senator Boner for an explanation of the House bill.
Senator Boner.
Thank you, Mr. Chairman. Ladies and gentlemen, what you have here is House Bill 175, pretty straightforward bill on page 2, simply protecting those kids in our public school system who are participating in ag-related programs. I think we can all know the names, which I won't say here on the floor, you know, dealing with our future farmers and so on. The problem is that even though that's clearly an academic program, clearly it's an activity, it's not always treated as an excused absence throughout all of our school districts. So that's basically what the bill does on page 2, lines 9 through 11, making sure that members of those programs are not treated differently than the kids are, say, in a sports program or doing some other sort of activity. Also want to make it abundantly clear that any event associated with our wonderful state fair, of course, is treated as an excused absence as well. Even though it's already in the statute, apparently we have to make that extra clear here on lines 12 and 13. Mr. Chairman, that's the bill. I'll stand for questions.
Senator Ellis.
Thank you, Mr. Chairman. I am curious if this has been a problem with school districts. My only concern with the bill, and I have nothing against the state fair, its associated programming, but just as we add to the list, it seems like there are so few things that we actually recognize in there as being excused. And we are very vigilant in protecting our ag kids, but just kind of the breadth of that as our students that are studying to become farmers. What about the other, I think they call them CTSOs, Career Technical Student Organizations. There are a number of them, some that focus on home economics or I don't know the more modernized term for that, but just a little discussion on why just ag and not something a little more broad.
Senator Scott.
Mr. Chairman, there was considerable discussion in committee that there wasn't consistency in the treatment of kids in these ag organizations. It seemed to depend from one time to the next and depend on which district you're in as well. But even within districts, there seemed to be confusion and inconsistency. And that's what produced the bill. And it's not strictly related to state fair related things. It includes ag organizations, particularly for the 2 of the larger ones that we deal with that were discussed in committee, and there just doesn't seem to be consistency, Mr. Chairman. We asked, were the number of excused absences getting to the point where it was interfering with education? And, Mr. Chairman, the answer we got was for the students that were participating in these organizations, it didn't seem to be a problem. Where they were being excused, they were making up the work and were well motivated to make up the work. But there was concern generally that of excessive excused absences. And Mr. Chairman, I tell you, but it focused more on the agriculture, on the athletic events than anything else. We may be needing to take a look at this subject in a much more general form at some point, Mr. Chairman. But this bill was brought specifically because there were difficulties with lack of consistency relating to the participation in the ag-related organizations.
Any further discussion? Senator Schuler, let me find you here.
Thank you, Mr. Chairman. Just a few questions. I don't mind this bill. I'm not in love with it necessarily, but I think it sort of takes away a little bit of the local control issue that we're always talking about. You know, sometimes we like local control until we don't like it. And I've always felt like, you know, you got to kind of trust in your school boards. But also I've had, you know, extended family members that have been involved in, you know, FFA and 4-H and judging and these kinds of things. And I just kind of wonder, because it says club, so it could be 4-H. It could be not something that's necessarily in the school. So I guess I just need a little bit more clarification that, you know, I understand state fair and I think that's a no-brainer, but just wondering if it makes it a little too broad and if it takes away our local control.
Further discussion, Senator Boner.
Thank you, Mr. Chairman. So this isn't adding any additional burden on any administrators. This isn't adding additional subject matter. Boy, I understand we have a pretty serious problem with micromanagement coming from the state down to our local school boards. I think we need a constitutional amendment to fix that, to fix some Supreme Court precedent. I don't think this is going to make an effect one way or the other on the amount of micromanagement that we have on our school districts. This is simply making sure there's consistency and that those kids who are participating in these very important programs are treated with fairness.
Any further discussion? Are we ready for the question? All those in favor of Senator Scott's motion that when the Committee of the Whole rises to report it, do so with a favorable recommendation of House Bill 175, please say aye. Aye. Those opposed, no? Okay, House Bill 175 has passed the Committee of the Whole. The next bill for your consideration is House Bill 21. Will the reading clerk please read in the report? Whatever it is.
House Bill 21, State Lands Use of Land Qualification Requirements, sponsored by the Agriculture Committee, an act relating to state lands. It was referred to Committee Number 5, which returned a committee recommendation that it do pass amended. Ayes, Senators French, Hicks, Ide, Kolb, and Steinmetz. Senator Steinmetz, Chairman.
Senator Steinmetz, what is your pleasure?
Mr. Chairman, I move that when the Committee of the Whole rises to report it, do so with a favorable recommendation that House Bill 21 do pass, and I would ask that the Standing Committee amendment be read in at this time.
House Bill 21, Standing Committee Amendment Number 1, page 3, line 8, delete.
And Mr. Chairman, I would move Standing Committee Amendment Number 1 to House Bill 21 and have the good Senator Ide explain the bill and the amendment.
Senator Ide.
Thank you, Mr. Chairman. This is a pretty straightforward little bill here with a few changes and an amendment. I'll go ahead and talk about the bill, and then I'll track in the amendment at the end. It's okay. So this bill basically is about requiring an applicant to have actual and necessary use of state lands to be qualified to lease state lands. And so in Wyoming Statute 365105, there's sections B and C. Those are the only changes that were made to that statute. And then at the very end, where we track in the amendment, there's an additional section J. So in B, on page 2, lines 3 and 4, all that's going on there is taking out that language that says has actual and necessary use for the land. And then in section C, lines 17 and 18, essentially does the same thing there, who has actual and necessary use of the land and available for forage.
and that was all taken out. And so it's kind of picked up in this added section J at the very end. And you can see lines 6, 7, and 8 is where basically picked up what they took out in B and C. And it says, no applicant shall be qualified to lease state lands for grazing and agricultural purposes without having actual and necessary use of the land. And then what was taken out of there is or forage at the very end of that sentence. And the amendment puts in for the production of agricultural commodities. So essentially what the discussion was there was you have, farmers and ranchers, that the ranchers graze and the farmers have forage. And that last amendment there basically picks them up and combines them together and for the production of agricultural commodities. So if there are no questions on the amendment, I call for the question.
All those in favor, any further discussion on the amendment? All those in favor of Senator Hyde's motion to adopt standing committee? Standing committee of the whole. Nope, this is, standing committee of the whole. Amendment number 1 to House Bill 21, please say aye. Aye. Those opposed? We're back on the bill. Question on the bill? Senator Scott. Mr. Chairman, based on a quick reading of the bill with interruptions, Mr. Chairman, I think I have a conflict of interest on it and will declare such. Any further discussion? Question on the bill? All those in favor of Senator Steinmetz's motion to when the committee of the whole rises to report it, do so with a favorable recommendation of House Bill 21, please say aye. Aye. Those opposed? House Bill 21 has passed the committee of the whole. The next bill for your consideration is House Bill 45. Will the reading clerk please read in the bill?
House Bill 145, Disclosure of Sensitive Information, Law Enforcement, sponsored by Representative Washut, an act relating to the administration of government, was referred to Committee Number 1, which returned to committee recommendation that it do pass. Ayes, Senators Case, Cooper, Furphy, Landon, and Schuler. Senator Landon, Chairman.
I believe I misspoke. I said House Bill 45. This is House Bill 145. Senator Landon, what is your pleasure?
Mr. Chairman, I would move that when the committee of the whole rises to report it, do so with a due pass recommendation on House Bill 145, disclosure of sensitive information, law enforcement. There are no amendments, and I'll stay right here and be glad to walk you through this good little House bill, Mr. Chairman. Our Department of Criminal Investigation is the repository for state law enforcement records and criminal intelligence. And there are rules, federal and state, as to whom DCI can share that information with. Law enforcement agencies and those state agencies authorized by law can receive this sensitive information. And that's what brings us to the purpose of this little bill, Mr. Chairman. Presently, Statute 91627 provides access to criminal identification and intelligence information to law enforcement agencies, the Border Patrol, the Department of Corrections, and the Department of Family Services. One of our newer state agencies, the Office of Homeland Security, is not listed. And that's what this bill aims to do. It's a very simple, straightforward bill. And if you go over onto page 2, you'll see that under statute 91627, and that's the statute that I just referenced, which allows for those agencies to receive the information, we track in the new language that includes our state Office of Homeland Security. And referencing 1913-105, that's the general duties and powers of our governor and also of our Homeland Security, which is officed under the governor. So what this bill will do, Mr. Chairman, is to make sure that we make it very clear in our statutory framework that we expect the Office of Homeland Security to have this information. Indirectly, we think that some of that information is available through the governor now. This bill, however, will make it crystal clear. Fellow senators, this is all an evolution of 911, to be honest. If you hearken all the way back to those pretty dark times, one of the biggest criticisms at that time was that agencies weren't able to talk to each other. We have worked on that front here in Wyoming and across the country ever since. We talked earlier in this session, for example, about our emergency communication system. This is the sharing of information that might make a difference. In testimony, Mr. Chairman, we heard that from the director that you never know what little piece of information might connect with some other piece of information that another agency might have and give us the ability to better protect our people. I think this is an important little bill. I'd be happy to answer any questions. Thank you.
Senator Ellis.
Thank you, Mr. Chairman. A question for the joint committee that brought this and the good bringer who just presented the bill. I had expressed some concern about another piece of legislation we looked at earlier this year about the ability to look up criminal records within the governor's office. I had experience in another state where that ability had been abused, unfortunately. It was used for political purposes and, people actually, I think, lost their job and some elections were affected by it. So I am kind of curious if there was any discussion on the narrowing of this sharing of information. Is it an open-ended ability to search records, or does it have to be tied to something that might have something like probable cause? We just want to make sure that we're not over empowering our agencies to fish for information when they don't have a reason to be looking for certain things.
Senator Anderson.
Mr. Chairman, I'm curious. I have an intelligence background in the military, and I see this as intelligence information. I wonder if we know what intelligence information is in this realm. Thank you.
Senator Salazar.
Thank you, Mr. Chairman. Yeah, I guess to piggyback onto the last one, I sit on the CERC, so I completely understand the importance of agency information being shared. But if the good chairman could talk a little bit about personal, individual information, whether it be, again, criminal records, credit reports, family information, travel information. How deep do we go before we get involved with perhaps personal constitutional privacy rights? Thank you.
Senator Rosas.
Thank you, Mr. Chairman. So looking at the bill and what exists in statute and what's elsewhere in statute, it seems like a reasonable extrapolation of existing statute to add this. And I think, Mr. Chairman, that I share the concerns of the other members that have expressed that fishing expeditions are possible, we can end up in the weeds, what are the privacy rights? I guess my concern is that this bill doesn't address that, and it doesn't necessarily make it worse. It seems like we're following on to the existing system in a rational way, but that the overall system might have some deep underlying flaws. So I would ask perhaps the members of the committee and the proponents of this, if there was any discussion of maybe going back and revisiting some of these concepts, the deeper underlying concepts of protection, privacy, fishing expeditions, proper use, elimination of records at some point. Do these records ever go away? Probably not. Should they? Probably. So, Mr. Chairman, I'd like to hear a little bit more about that broader discussion on the data privacy and protection aspect of this. I do see how it fits into statute, but I guess I have deeper concerns. Thank you.
Senator Landon, some simple questions for you.
Mr. Chairman, I better get started answering a couple of those. Very good questions, all of them. Is this too intrusive, and is it going to lead to the Department of Homeland Security delving too deeply into people's private lives or information? Honestly, for this particular bill, we did not go there. But I will say that the language on page 2, while it may not have as tall a sideboards as we would like, it certainly says that each agency which has this information shall take reasonable security precautions. It also talks about the rules and procedures may be different among the agencies depending on how they need that criminal identification and intelligence information. Regarding intelligence information, that is interstate and frankly worldly, the information that comes to the Department of Criminal Investigation. And ultimately, it is up to the Department of Criminal Investigation what information is shared with our agencies. This is quite a web of protection that is out there. And so be happy to try to delve a little bit more deeply into the question posed by my friend from over the mountain. We did not get all the way into how long are these records, since this particular agency has never been a part of this information sharing, we didn't get into how long are you going to hang on to that information, or what exactly are you looking for. I think it's important to them just to be in the network so that when and if it makes sense, they are included in the sharing of this information. I'll be glad to try to answer other questions, or certainly we'll chase down the information needed for second reading. Thanks, Mr. Chairman.
Senator Ide.
Thank you, Mr. Chairman. On and against this bill, boy, this is dangerous, slippery slope. You know, the violation of our Fourth Amendment rights to privacy without warrants to gather information. I don't like this bill. On and against it. Thank you.
Senator Boner.
Thank you, Mr. Chairman. Boy, that's an extraordinary thing to think about without providing any evidence to the previous speaker. If there's some sort of violation of Fourth Amendment, I suggest we take it up in the courts. And this is, like we point out, a current practice. We're extending it to our State Department of Homeland Security. I point out that, for example, I can't speak to the common practices, to the minority leader's point about criminal investigations. I can tell you that the lead of our state Homeland Security, the department director, has a top secret clearance. Many of our staff has a secret clearance. There are rules that govern that aren't just outside the purview of our Constitution, I think, as was implied here. There's very strict rules, stricter than anything I'm sure we have at the state level in terms of controlling information. And so there's an existing structure that I agree we probably need a little bit more background on with this bill, but those structures do exist. Just having that personal experience to that sliver of it, I can tell you that those protections are very robust and very serious. And that information isn't going to be shared with anybody who doesn't need to know it. And if there is, there's going to be serious legal consequences for the individual that does.